You're sitting on this couch, late evening. The living room is dark except for the glow of your phone screen. You hear it before you see it. Buzz, buzz, buzz. Another unknown number. Another voicemail notification. Another message you don't want to check. You flip the phone over so you don't have to look at it. But you already know what it is. A debt collector. Calling again. You tell yourself you'll deal with it later. Tomorrow. Next week. You've been telling yourself that for a long time now. Maybe it'll stop. Maybe they'll give up. Maybe it'll somehow just go away on its own. But ignoring a debt collector doesn't make the problem disappear. It makes the consequences appear. And they only get worse the longer you wait. If you've ever felt your stomach drop when an unknown number calls, comment yes. Because millions of people are in this exact moment right now. And most have no idea what really happens when you ignore a debt collector. Before we go further, let me be clear. This is educational storytelling about debt collection laws, rights, and consequences, not legal advice. Rules vary significantly by state and situation, so always consult qualified professionals before taking action on any debt. When a debt goes unpaid long enough, could be a credit card, medical bill, personal loan, even a utility bill, it eventually gets sent to collections. The original creditor gives up and either sells your debt to a collection agency for pennies on the dollar, or hires one to collect on their behalf. At first, that means calls. Lots of calls. Early morning, late evening, your cell, your work phone, your landline. Voicemails that sound urgent, official, designed to create crisis and make you feel like you need to call back immediately. Messages that use legal-sounding language, references to your file and account review, and urgent matter requiring your attention. If you ignore them, they escalate. They switch numbers so you can't block them effectively. They call from local area codes because people are more likely to answer calls that look like they're from nearby. From numbers that could be your dentist or your kid's school or a local business. Letters start arriving, official-looking envelopes, sometimes designed to look like legal documents or government mail. Full of legal language. Terms like final notice and demand for payment and intent to pursue legal remedies. Emails if they have your address. Text messages in some cases, though there are stricter rules about texting. This isn't harassment in the legal sense. There are laws, specifically the Fair Debt Collection Practices Act, that limit how often they can contact you and what times they can call. They can't call before 8 a.m. or after 9 p.m. in your time zone. They can't call you repeatedly with intent to annoy. They can't contact you at work if you tell them your employer prohibits it. But within those legal limits, they're relentless, because that's their job. They're incentivized, often paid on commission, to collect. The more persistent ones are the most successful. Collectors know that most people hide from debt. It's a natural human response. Avoidance. Hoping it goes away, pretending it's not happening. So their strategy is simple and proven effective. Wear you down. Outlast your avoidance. Apply consistent legal pressure until you finally respond out of exhaustion or fear or just wanting the calls to stop. And while you're avoiding calls and not opening letters, something else is happening behind the scenes. Something most people never see until it's too late. Something that's building against you every single day you stay silent. Here's what most people don't know. What collectors don't advertise. When you ignore a debt collector, they document everything. Every single interaction attempt gets logged into their system with timestamps and details. Every call they make to you, noted. Time, date, number called, whether you answered, whether it went to voicemail, sometimes even notes about what the voicemail said. Every letter they send, recorded. Date sent, address used, type of letter. Whether they used regular mail or certified mail with delivery confirmation. Every email or text, logged with date, time, exact content. Every failed attempt to reach you, documented as evidence of their good faith effort to communicate. And that growing file, that detailed record of attempted contact, it's not just bookkeeping for their internal tracking. It's evidence. Evidence they can use if they decide to sue. Evidence that shows they tried repeatedly to communicate and you consistently refused to respond or engage. Evidence that demonstrates to a court that they acted reasonably within legal guidelines, that they gave you opportunities, that they followed proper procedures, that you were the one who wouldn't cooperate. Your silence, your avoidance, it's all being turned into their advantage, into documentation that strengthens their position if this ever reaches a courtroom. Meanwhile, the debt itself doesn't stay still while you're ignoring it. The balance doesn't freeze just because you stopped looking at it. Interest continues to accumulate if it's a debt that carries interest. Late fees get added, often every 30 days. Collection fees get tacked on, the cost of them pursuing you. In some cases, attorney fees get added if the original contract allowed for it. Some debts can double or even triple over the course of months or years of non-payment and accumulating charges. What started as a $2,000 credit card balance becomes $4,500. A $5,000 medical bill becomes $8,000 when collection fees and interest compound. And you're not seeing any of this because you're not opening the letters or checking your credit report. But it's happening, growing, getting worse. Most people don't answer the phone or open the letters because they're afraid of what they'll hear, afraid of confrontation, afraid they can't pay and will have to admit that out loud, afraid of being judged or pressured or manipulated into agreeing to something they can't afford. The anxiety is real, the stress is real, the feeling of being overwhelmed is real. But here's the trap nobody tells you. Ignoring doesn't avoid consequences. It just removes your ability to control which consequences you get and when they happen. Stop scrolling for a second. This part is where most people lose thousands of dollars they didn't have to lose. Here's what happens to your credit while you're pretending the problem doesn't exist. First, the original creditor reports the late payments. 30 days late, that's a mark on your credit report that damages your score. 60 days late, another mark, more severe. 90 days late, even worse. Each successive late payment drops your credit score further. Then, when the account goes to collections, when the original creditor charges it off and sends it to a collection agency, that gets reported too. The account status changes to in collections on your credit report. And that single status change, that one line on your credit report, can drop your score by 50 to 150 points or more, depending on what your score was before and what else is on your report. For someone with good credit, a collection can be devastating. The higher your score was, the harder it falls. And here's the part that really hurts. That collection typically stays on your credit report for 7 years. 7 years from when the account first became delinquent with the original creditor. Even if you later pay it off completely. Even if you settle it for less. Even if you negotiate and handle it properly afterward. The mark stays for 7 years. Ignoring the debt doesn't protect your score from damage. It guarantees maximum damage while you pretend nothing's happening. And that matters more than most people realize. Your credit score isn't just about whether you can get a credit card or a loan. It affects everything in modern life. Apartment rentals, landlords check credit reports before approving applications. Many won't rent to someone with recent collections or judgments. You might get rejected from housing you need because of a debt you've been ignoring. Job applications in certain industries, especially finance, government positions, jobs requiring security clearances, sometimes healthcare, they check credit as part of background checks. They're looking at whether you're responsible, whether you might be a financial risk, whether you can be trusted. Collections can cost you job opportunities. Insurance rates, car insurance, homeowners insurance, renters insurance. They use credit-based insurance scores that factor in your credit report. Worse credit means higher premiums. You pay more every month for insurance because of collections on your report. Interest rates on any loan you manage to get, mortgage, auto loan, personal loan, worse credit means dramatically higher interest rates. We're talking differences of 2, 3, 4 percentage points or more. On a $250,000 mortgage, that's tens of thousands of dollars in additional interest over the life of the loan. On a car loan, that's thousands extra. If you're starting to see why silence isn't protection, comment trapped. Because that's what ignoring debt does. It traps you in consequences you could have potentially avoided or minimized. Stay with me, because the next consequences are the ones most people never see coming. Debt collectors don't immediately sue everyone who ignores them. That would be inefficient and expensive. Lawsuits cost money, filing fees that can be hundreds of dollars, attorney fees if they hire lawyers, court costs, their time and resources managing litigation. It's time-consuming. Court processes take months, sometimes over a year from filing to resolution. And it's not guaranteed to work unless they're confident you have income or assets they can actually collect from after winning. There's no point in suing someone who's judgment-proof, someone with no job, no bank account, no property, no wages to garnish. Even if they win a judgment, they can't collect anything, so the lawsuit was a waste of money. So before they take legal action, they escalate your file internally through their collection process. If you ignore them long enough, usually after several months of no response to calls and letters, your account gets flagged for what's often called pre-legal review or attorney review. That means someone with more authority examines your file closely. A supervisor, a legal department staff member, sometimes an attorney who works with or for the collection agency. They review all the documentation, all those logged calls and letters we talked about. They're making sure the file is solid, that they have evidence of attempting contact, that they've followed proper procedures. They check your state laws to understand what's allowed, what the procedures are, what the timeline is for filing suit. Every state is different. Some have shorter timelines, some longer. Some have specific procedural requirements. They check whether your debt is still within the statute of limitations, whether enough time has passed that they've lost the legal right to sue you. If the statute has expired, a lawsuit would get dismissed, so there's no point filing. They look for signs that you're collectible, that you're worth the expense of suing. Collectors may sometimes access credit reports if they have a permissible purpose under federal and state law. This varies significantly by jurisdiction and circumstances. They review past payment information or data sources that might indicate where you bank, whether you have assets, whether you're employed. If you appear collectible, if you have a verifiable job, if there's evidence of financial accounts, if you own property, you just became worth the cost of suing. The potential return justifies the investment. Your file gets upgraded from standard collection to legal action recommended. Here's the trap hardly anyone understands. That's when the process typically shifts from negotiable to legal. In many states, collectors send a final written notice before legal action, sometimes explicitly required by state law, sometimes standard practice to protect themselves legally. This letter might be called different things: intent to sue, final notice before legal action, demand letter, pre-litigation notice. The exact name varies depending on the collector and jurisdiction, but the message is always the same. This is your last chance to handle this before we take you to court. After this deadline, we will file a lawsuit. This letter typically gives you a deadline, usually 10 to 30 days depending on the collector and jurisdiction, to respond, to pay in full, to set up a payment arrangement, or to otherwise resolve the matter. It often includes the total amount they're claiming you owe, including all accumulated interest and fees. It might include settlement options: pay 50% now to resolve it, pay 70% over 6 months, something like that. Or it might just demand payment in full. It usually includes language about legal action, about potential wage garnishment, about consequences you'll face if this proceeds to court. It's designed to create urgency and fear. If you're ignoring phone calls and not checking your mail, or if you're checking it but just throwing away anything that looks like it's from a debt collector without reading it, this is the letter most people miss. The most important letter in the entire collection process, the one that actually matters, the one that gives you your final opportunity to stop what's coming. The last off-ramp before the legal highway. Pause. Because this detail changes everything. After this letter, you often still have options. You can still negotiate. You can still request validation of the debt and force them to prove it. You can still potentially settle for a fraction of what they're claiming. But only if you act. Only if you respond. Only if you engage before that deadline passes. After that deadline passes with no response from you, the decision to sue has usually been made. The file has been approved for legal action, the paperwork gets prepared, the lawsuit gets filed with the court, and then the process typically unfolds quickly. One day, could be weeks or months after that final letter you didn't read, there's a knock on your door. You open it, and a stranger you don't know hands you papers and says, "You've been served," and walks away. That person is a process server, hired by the court or the collector's attorney to deliver legal documents. Or maybe you get a certified letter that requires your signature, and inside are court documents. Or in some states, service happens by regular mail sent to your last known address, or even by publication in a local newspaper if they can't locate you. However it happens, the message is the same. You've been sued. A debt collector has filed a lawsuit against you in civil court. You are the defendant. They are the plaintiff. There's a case number. There's a court date for a hearing or trial. There's a complaint, a legal document that lays out their allegations. They're claiming you owe them X amount of dollars. They're asking the court to issue a judgment ordering you to pay. There's a legal process that has officially begun. You're now part of the court system. This is public record. Anyone can look up your case online in most jurisdictions. The moment you're served with lawsuit papers, you have a countdown. Usually between 14 and 30 days depending on your state and the specific court procedures. Some states give you 20 days, some give you 30, some as few as 14. That's how long you have to file a response with the court, a document called an answer, where you respond to each allegation in their complaint. Where you admit what's true, deny what's not true, and raise any defenses you have. This response matters enormously. This is where you can dispute the debt, where you can challenge whether they actually have the legal right to collect it. Maybe they can't prove they own the debt. Maybe the statute of limitations has expired. Maybe they're suing the wrong person. Where you can argue that the amount is wrong, that they've added fees or interest they're not entitled to, that their calculations are incorrect, where you can raise affirmative defenses, that the debt was discharged in bankruptcy, that you already paid it, that it's not your debt, that they violated collection laws in pursuing it. This is your opportunity to fight back, to make them prove their case, to protect your rights. But here's what most people do. They ignore the lawsuit too. They're already in the pattern of avoidance, already overwhelmed by the situation, already convinced there's nothing they can do. They don't know how to respond to a lawsuit. They can't afford a lawyer. They're scared of court. They're ashamed. They're paralyzed. So they do nothing. They put the papers in a drawer and try to forget about them. They miss the deadline. They don't file an answer. They don't show up to any hearings. And when you don't respond to a lawsuit, when you don't file that answer within the deadline, the debt collector typically wins automatically. Not because they proved their case, but because you didn't respond. This is called a default judgment. The court issues a judgment in their favor by default because you failed to participate in the process. Once a debt collector has a judgment against you, the situation shifts significantly. A judgment is a court order. It's not just a debt anymore. It's a legal finding that you owe this money. It's enforceable through the power of the court. With a judgment, they can typically request, and courts usually grant, various collection remedies. Wage garnishment. In many states, a percentage of every paycheck you earn gets taken out before you even receive it. The money goes directly from your employer to the judgment creditor. Typically, 15 to 25% of your disposable income. Your income after mandatory deductions like taxes and Social Security. Some states allow more. Some allow less. Federal law sets a maximum, but state laws can be more protective. But either way, a chunk of your paycheck disappears every pay period. You never see it. Your employer is legally required to comply with the garnishment order. They don't have a choice. This continues every paycheck until the entire judgment is satisfied. The original amount, plus all the interest that's been accumulating on the judgment, plus court costs, plus sometimes attorney fees. If you're living paycheck to paycheck already, wage garnishment can be devastating. Suddenly, 15 or 20% of your income is gone, and you can't pay rent or buy groceries or keep up with other bills. Bank account levy. They can get a court order, usually called a writ of execution or writ of garnishment depending on your state, to freeze your bank account and remove money directly. You go to the ATM to get cash and your card doesn't work. You try to pay a bill online and the payment fails. You check your balance and your account is frozen. The bank has received the court order. They freeze your account immediately to prevent you from withdrawing the money. Then they take whatever money is in there, up to the amount of the judgment plus fees, and send it to the judgment creditor. Doesn't matter if that money was for rent due tomorrow. Doesn't matter if that was grocery money. Doesn't matter if that was your entire paycheck that just got deposited. It's gone. In some states, certain funds are protected. Social Security benefits, disability payments, some public benefits, but you have to prove that's what the money was. And in the meantime, your account is frozen and you can't access anything. Property liens. If you own a home, land, or other real property, they can attach a lien to the property. That means the judgment becomes attached to your property ownership. You can't sell the property without paying off the judgment first. The lien has to be satisfied at closing. So if you ever sell your house, they get paid out of the proceeds before you see a dime. You can't refinance your mortgage without dealing with the lien. Any title search will show it. Any attempt to transfer the property will trigger it. The lien just sits there, attached to your property, growing with interest, because most judgments accrue interest, often at rates set by state law. A $5,000 judgment becomes $8,000 over time. A $10,000 judgment becomes $15,000, and it stays there until it's paid or until it expires, which in many states is 10 years or more, often renewable. Court-ordered payment plans. In some cases, especially if you don't have significant wages to garnish or money in the bank to levy, they can bring you back to court for what's called a debtor's examination or supplemental proceedings. The court orders you to appear and bring financial documentation, pay stubs, bank statements, tax returns, proof of expenses. You have to answer questions under oath about your income, assets, where you work, where you bank. Based on that information, the court can order you to make monthly payments toward the judgment. You don't get to negotiate the amount. The court decides based on the financial information you provided. In some jurisdictions, failure to appear for a court-ordered debtor's exam may result in a bench warrant, not for the debt itself, but for missing the hearing. This varies significantly by jurisdiction. These aren't theoretical threats. These are actual legal mechanisms that happen every single day across the country to people who ignored debt collectors, who didn't respond to lawsuits, who ended up with default judgments. Stay with me. This next part is where most people get blindsided. Good news. You still have more power than you think, but you have to use it before things escalate to judgments. If you engage early, before lawsuits, before judgments, when it's still just phone calls and letters, you often have significant real options. Real leverage, real ability to control what happens. When you communicate before things escalate to legal action, you can typically request written validation of the debt. Under the Fair Debt Collection Practices Act, a federal law that applies in all states, collectors must prove that you owe the debt, that the amount is correct, and that they have the legal right to collect it. You have to request this in writing within 30 days of receiving their first written notice, as required under the FDCPA. Send a certified letter requesting debt validation. Make them prove it's your debt, prove they own it, prove the amount is accurate. Many collectors, maybe even most, cannot adequately validate debts, especially debts that have been sold multiple times between different collection agencies. The paperwork gets lost. The documentation is incomplete. They can't prove chain of ownership. If they can't validate the debt properly, they're legally required to stop collection activities. They can't keep calling. They can't report it to credit bureaus. They have to leave you alone. That validation request, that simple letter, can sometimes make the entire problem go away. Not because you didn't owe the original debt, but because they can't prove you owe it to them specifically. Dispute incorrect amounts. If the balance they're claiming includes fees or interest that shouldn't be there, if they've added charges that aren't legitimate under the original contract, if their calculations are wrong, you can challenge that before it becomes a judgment. Negotiate payment plans. Most collectors would genuinely rather get some money reliably than risk getting nothing. They know that suing is expensive and uncertain, so they'll often agree to monthly payment plans that fit your actual budget. Maybe $50 a month, maybe $100, whatever you can actually afford. Because getting something monthly is better than getting nothing at all. Negotiate settlements for less than the full amount. This is significant. Many consumer attorneys and nonprofit credit counselors report that collectors sometimes settle for 30 to 50% of the balance or even less, particularly if you can pay a lump sum. This varies widely by state and circumstances, because collectors, especially those who bought your debt from the original creditor, often paid pennies on the dollar for it. If they paid $200 for a $2,000 debt and you offer them $800 to settle it completely, they're still making profit. Stop the calls legally. Once you send a written request telling them to stop calling you and only contact you by mail, they must comply under federal law. You can control the terms of communication. Prevent escalation to legal action. By engaging, by communicating, by showing you're addressing the situation, even if you can't pay the full amount immediately, you often prevent your file from being flagged for legal action. Collectors generally prefer cooperation over court. Court costs them real money. Outcomes aren't guaranteed. They'd much rather negotiate and actually get paid. Talking early, engaging strategically, that gives you leverage. Silence removes it entirely. Here's something critical that people dealing with old debt need to understand, something that can literally save you thousands of dollars or cost you thousands depending on whether you know it. Every state has what's called a statute of limitations for debt collection lawsuits, typically somewhere between 3 and 6 years, depending on your jurisdiction and the type of debt. Written contracts often have longer statutes than oral agreements. This is a time limit. After the statute expires, they can no longer sue you to collect the debt. They've lost the legal right to force payment through the court system. Once expired, the debt becomes what's called time-barred. They can still call you, they can still send letters, they can still ask you to pay. Nothing in the law stops them from attempting to collect a time-barred debt. But they cannot sue you. They've lost the legal mechanism to force payment. And if they try to sue anyway, you can get the case dismissed by raising the statute of limitations as a defense. This is powerful protection. But here's the trap. Depending on state law, making a payment or formally acknowledging the debt may restart the statute of limitations. This varies widely by state and circumstances. Sometimes a payment is enough to restart it. Sometimes it requires written acknowledgement of the debt. Sometimes both are needed. Sometimes neither can restart it once it's expired. The rules vary significantly from state to state, but in many states, making even a small payment on a time-barred debt can restart the clock, can reset the statute of limitations, and turn an old, uncollectible debt into a fresh debt they can now sue you for. Debt collectors know this. They're specifically trained on statute of limitations rules, and they use that knowledge strategically. They'll say vague things designed to get you to make a good faith payment without explicitly telling you the consequences. They'll pressure you to pay something, anything, even $5, even $10, just to get you to make a payment. Here's a real example. Someone gets a call about a 6-year-old credit card debt. The statute of limitations in their state is 5 years for written contracts. That debt is time-barred. The collector cannot sue them. But the person doesn't know this. The collector is friendly, understanding, says if they can just make a small payment today, even $25, it shows good faith. The person makes the $25 payment trying to do the right thing. In their state, making a voluntary payment on a debt restarts the statute of limitations. That payment turned a time-barred debt into a fresh debt with a new 5-year window where they can be sued. 3 months later, they get sued for the full balance. And that one $25 payment is cited as evidence that they acknowledged the debt. Never make any payment on old debt until you verify the statute of limitations in your state and understand the implications. This varies widely by state and circumstances. If this is already opening your eyes to how much you didn't know, hit subscribe. The next video is the exact script collectors hate, the specific language that actually protects you. So if ignoring is the worst strategy, what should you actually do? Not legal advice, these are educational approaches that consumer protection experts often discuss. Always read all mail from collectors. You need to know what they're saying. Some letters contain rights information, deadlines, lawsuit notices. Request debt validation in writing within 30 days. Send certified letter. Make them prove it. If they can't validate, they typically must stop collection activities. Check statute of limitations in your state. Knowing whether you're dealing with a time-barred debt changes everything. If sued, always respond. Even without an attorney. Filing an answer prevents default judgment. Many courts have forms available. Legal aid organizations can often help. Consider working with a consumer rights attorney. Many offer free consultations. If violations occurred, some work on contingency. Get everything in writing. Every agreement, every payment plan, every settlement. Written documentation protects you. Here's what you should never do. Never give bank details over phone. If you decide to pay, do it in writing after getting terms documented. Never make small payments on old debt without checking statute of limitations first. Could restart the clock. Never ignore lawsuit documents. Even a basic response changes everything. The pattern is clear. Strategic engagement beats silence. You have rights under federal and state law, but those rights only matter if you use them. Let's talk about what happens emotionally when you're in this situation. Because the stress is real, the fear is real, the shame many people feel is real. There's this voice telling you you're a failure, that you're irresponsible, that you're the problem. And that voice keeps you silent, keeps you hiding. Because facing the debt means facing that shame. But you need to understand, you're not alone in this. Millions of Americans are dealing with collection debt right now. It's not because they're all irresponsible or failures. It's because life is expensive. Because wages haven't kept up with costs. Because unexpected things happen. Because the financial margin for error has disappeared for most people. The system is structured in a way that often creates debt. You're not a moral failure because you have debt. You're a normal person navigating difficult economic realities. And ignoring the debt doesn't make the shame go away. It makes it worse. Because now you have the shame plus the anxiety of unknown consequences building. Facing it, engaging strategically from a position of knowledge, actually reduces the emotional burden. Because uncertainty is often worse than reality. Taking action, getting information, understanding your position, that gives you back some control. Some agency, some sense that you're not just a victim, but someone actively managing a difficult situation. When you ignore a debt collector, it feels like you're avoiding stress, like you're protecting yourself, but you're really guaranteeing worse outcomes. You're giving up every advantage. You're handing them control of the entire process. Silence doesn't save you from consequences. It removes your ability to influence which consequences occur and when. Knowledge protects you. Understanding how the process typically unfolds, what your rights are, what you should and shouldn't do, that's your defense. Action protects you. Engaging strategically rather than hiding passively. Making informed decisions rather than reacting from fear. The system is structured in a way that often disadvantages people who stay silent. It counts on your silence. The entire debt collection industry is built around the fact that most people will hide, will avoid, will not respond. Once you see that, once you understand that silence isn't protecting you, everything changes. You can start making strategic decisions based on knowledge rather than fear. You can start using the rights that the law provides. You can start negotiating from a position of understanding. You're not helpless, you're just uninformed. There's a huge difference, and that difference determines outcomes. Helpless means there's nothing you can do. Uninformed means you don't yet know what you can do. One is permanent. The other is fixable with information. You have more power than you think. Not unlimited power, but real power. Meaningful power that can influence outcomes if you know how to use it. The power to request validation. The power to dispute amounts. The power to negotiate settlements. The power to stop calls legally. The power to respond to lawsuits. The power to raise defenses. The power to understand statute of limitations. That power was always yours. You just didn't know it existed. But now you know. If you want the full follow-up, the detailed tactical guide with exact scripts, how to respond to a debt collector, what to say word for word, comment, respond. Because this video was about understanding the consequences of ignoring, about seeing clearly how the process typically unfolds when you stay silent. The next video is about what to do instead. Concrete actions, specific language, exact steps, proven strategies for responding effectively, real tactics for real situations, not vague advice, but specific approaches that consumer protection attorneys discuss and recommend. Your ability to change your situation starts with understanding the process, and now you understand